26, Your Ladyship. Yesterday it was mentioned, and considering the urgency, Your Ladyship has posted the case for today. Your Lordship, I am praying that this matter may be taken up in the first half at any fixed time, Your Lordship. I have already taken consent for fixing a time from the respondents, Your Lordship. It's a civil review matter. Only on a very small technical point is there that an LBA was allowed on a similarly situated person. Your Lordship, any time. Your Lordship, 250.
Inform us.
Yes.
From the list, daily section number 10. इसका सुन लिया जाता
Sorry,
सेकेंड अपील नंबर 106/2024.
what do you want?
इस पर सुन लिया था जाता
हर केस में तो आप टाइम मांगते हैं, आज सुनने के लिए क्यों तैयार हो?
इसमें इंट्रीम ऑर्डर है जो राजा आज तक है.
सीरियल नंबर 10 में इंट्रीम ऑर्डर है जो आज खत्म हो रहा है. देखिए क्या होता है. Just wait for you.
This case from supplementary list item 13, second appeal 187/2008.
Mr. Sharma, एक केस के बाद
एक केस के बाद जो है 2 घंटा बाद टेकअप. एक नेक्स्ट केस भी हियरिंग के लिए ही है. तब तक हम लिखा सेकंड अपील नंबर 187/2008.
Lord, may I permitted to read out the trial court judgment, Lord. Till then,
आपको टाइम पास करना है.
नहीं वो जो एक फैक्चुअल एरर है. It is एकदम with regard to a share of the doubters. जरा सा हमको पढ़ने दिया जाए.
क्या फैक्चुअल
फैक्चुअल एरर है.
टेक्स्ट हम लोग पढ़.
डाउटर्स को कुछ नहीं दिया, जबकि जरा सा पढ़ा जाए ना जो ऑपरेटिव पोर्शन. इसमें ऑपरेटिव पोर्शन में देयर इज नो प्लेंटिव नंबर 7, but it has from operative portion it appears that this plaintiff number 7 has been given the share. वो फैक्चुअली एरर है. और उसके बाद ऊपर में देखा जाए पेज 19 से पेज 19 में
आपको बहस करना है क्या केस में? सर को ब्रीफ कर दिया है ना.
हाँ
इसका बाकी सब एक मिनट बैठ जाइए स्टेशन में. प्लीज सिट डाउन फॉर अ व्हाइल.
But perhaps this is the most difficult proposition of law today. It is.
आपके लिए डिफिकल्ट है तो मेरा क्या
I'm
होगा?
saying so, Your Lordship. Because my lord, I examined the judgments, etc. My lord, the proposition of law, Your Lordship, in this particular case, Your Lordship, that my lord, the daughter, my lord, whose father died way back in 1956. Prior to 1956, or as per us, it is 1936. My lord, what would be her right? And this case has another peculiarity. On that, I could not find any direct judgment. There are some judgments that I will be showing. Here in this case, Your Lordship, that my lord, the widow, Your Lordship,
So Hagi Devi, widow of Radha Mato, she remarried with the Malad Kashi Mato. This is a very important factual aspects, because I examined Sanskrit law also. Arunachala judgment also, which my learned friend has cited, and earlier also my lord has gone through that judgment while I was arguing that case. My lord, that judgment, your lordship, will find that my lord, Hindu law, my lord, Mitakshara law, with respect to daughter's right, my lord, with respect to separate property has been considered in that Arunachala judgment. Basically, my lord, in that case, my learned friend has relied upon that judgment. But actually, that judgment is not relevant at all for that purpose. But I examined very closely that matter, my lord. Arunachala judgment, 2022, SCC online, and my lord, it is reported in SCC also. My friend has given that judgment. That judgment, your lordship, that judgment, when my lord will go through all my lord, the aspects, my lord will find that in that particular case, the father, my lord, had died way back in 1949. And my lord, there was only one daughter. In that case, my lord, there was only one daughter. Relying upon my lord, Mitakshara law and several judgments of Privy Council, Allahabad High Court, and several other judgments, Honorable Apex Court has examined the law in that particular case. That is with respect to the separate property. I agree to that. But my lord, here, my lord, in this case, my lord, even Arunachala judgment, my lord, the issues is far more complex than, my lord, in this particular case. And because there is a widow, and my lord will find, my lord, I will show it from the mullah. My lord, even if, my lord, if lordship will take into consideration the, my lord, the Mitakshara law and the other, my lord, the commentaries that has been taken note by the Honorable Apex Court in that case, subsequently relied in the Bombay also and other Chhattisgarh judgments also. But in those cases, my lord, there was no widow. Here in this case, my lord, what happens, my lord? In the night, and there is a peculiar circumstance in this case is also, my lord, that, my lord, the right, my lord, the act, my lord, Hindus widow, the act, my lord, that come, my lord, in 1937. Here the death occurred in 1936.
That there is no finding.
My lord?
There is no finding to this effect.
No, but it has come.
No.
It has come.
We are not going to take that.
Anyway, my lord, may kindly appreciate.
Because that will lead to another substantial.
No, I'm my lord is well aware of it. My lord is well aware. So far as the barrier part, your lordship, is concerned, the barrier part is on the RC. It's not on the bond. My lord, may kindly see section 103, section 100 subclause 3. If any substantial question of law, your lordship, arises.
No, you see, we do not have any clear finding by the court as to when did her husband died. There is no specific date which is coming up.
In the written statement, they have
No,
also.
written statements are
They
being
have no.
You see, before 1937 or after 1937, that is beyond the scope. Because there is no finding
In
recorded. by
either
the
situation, my lord, what I want to contend, my lord, on death of Radha Mato, there was a widow and two daughters existing. The right will go to widow, even as per the Shastric law. And once the widow remarries, my lord, then it will not go to the daughters, my lord, it will go to the reverse. That what is the law? Even as per the Shastric law also. The lordship may kindly have a look on the law. Mahjub Mullah Kutwa place correct. 20th edition place correct.
So you want to say that on death of Radha Mehto, it will devolve upon his widow and 2 daughters.
No, it will devolve upon the widow.
Upon widow.
At the moment it will devolve upon
And
widow.
upon marriage of widow
After remarriage, my lord, it will go to reverseness.
to agnates.
Agnates. The daughter will not come into picture. My lord, may kindly see, my lord, Hindu law. Your Lordship. My lord, if it is the same book, then my lord, I will be placing 129 pages. Pages are in the bottom. Section 43.
You just tell me one.
Yes.
Suppose there is sole legal heir of a
So legal.
sole co-pastor,
Well,
single co-pastor. And after death of his father, he acquires the property. Correct? And then there is no occasion of any partition because he is the only one. This happens prior to 1956. And post 1956, a daughter is born in the family. What is this, or maybe a son and a daughter are born in the family. What will be the status of this body?
that has been taken not my lord, in the judgment.
So, co-custody as a body will keep on increasing or decreasing depending upon how and when the persons are dying in the family.
Yes.
Correct?
Yes.
So, if a person who acquires a property singly and he does not dispose it off prior to coming into force of 1956 Act, and a son is born in the family, then under such circumstances he cannot dispose it off after the son is born.
Yes.
Correct?
That I already argued. My lord has already. My lord has taken this into consideration. Already consideration in the Devanandan group also. So, my lord, this is not. It is a second settled legal position. But my lord, the point is actually there should be a son.
And suppose a daughter is born.
No, then the position won't be the same. Won't be same.
Just a moment.
So far as the co-pastory property is concerned, because
You see, what difference does 2005 Act, we understand that daughter acquires the status of a co-pastor. What is the impact of 1956 Act?
1956 Act, my lord, they were not co-pastors.
No, what is that revolutionary which happened in 1956 Act so far as rights of daughters are concerned?
Yes, my lord has rightly my lord asked this question. What I understood, very humbly I want to submit. My lord, the daughter right has been given, my lord, by virtue of this Act of 1956 in the father's property. Suppose, my lord, a partition opens.
In this father's property means self-acquired property
No, I'm coming to
or the property
Yes,
obtained by partition?
I'm coming to that. What happens, Your Lordship? The moment a partition opens, then my lord, father being a co-partner, he will have a share in the property apart from the other co-partners. If a notional partition is, my lord, is effected, then my lord, out of the father's property, Your Lordship, whatever may be getting as a co-partner his share, in that property, Your Lordship, every son and every daughter, Your Lordship, will have the same. But so far as the sons are concerned, sons will have a share of co-partner as well as in this property. But so far as the daughter is
If
concerned,
a father, if there is a partition in the family
ma'am,
and father acquires a property
yes,
by virtue of partition,
yes,
right?
yes.
Then qua his sons and daughters.
Why in sons and daughters the right is equal?
Right is equal
So far as
pursuant
his
to
share is concerned. So far,
pursuant to 1956 Act.
pursuant for 1956,
Pursuant to 1956.
66.
So they get equal property
In the father's share only.
in the father's share.
But so far as the son is concerned, I kindly appreciate there is the fine line of distinction. So far as the son is concerned, he will take a share equal to the father because he is the co-pastor. So far as the daughter is concerned, Malad, pre 2005 Act, she will
We are not in 2005, we are in 1956.
yes, she will only take a share in the father's property. This is the distinction. Now, Malad, as per the post.
Not like this.
No, this is like this.
Father has acquired the property from grandfather.
Yes,
Right?
yes.
By virtue of partition.
But
By virtue of partition, he
Right.
acquires a property.
yes,
And once he acquires a property,
but
does it become his individual property or it continues to be a co-pastoral property?
no, it continues to be a property. Malad. There is a rider.
It is a property.
There is a rider. There is a rider. Their son should be born. There is a rider. The son should be born. Once a son is born, Malad, in a family, then Malad, it will continue as a co-pastoral. But suppose
Suppose no son is born.
prior to birth of a
Suppose
son,
no son is born, only daughter is there. She will have no right.
she may have a right. Malad. She may have
What
a right.
right? Then she will inherit the entire property. Or in spite of partition, in spite of father getting property by virtue of partition, right? This property will go to the annex.
So, no, I'm coming to that. But not suppose a daughter, there is only a daughter. And it is a compulsory property. Then, Malad, so far, if it is a compulsory
It is
property,
not a co-pastoral property anymore because partition has already taken place.
no, so far as this case is concerned, Malad, I'm not on this case. Your Lordship Malad,
Yes,
is
yes.
asking just a Malad, a situation. We are discussing the situation. If it is a compulsory property, Your Lordship, then Malad, the daughter will have no right. Unless and until, Malad, if the partition is done with the co-partners and out of the share which the Malad, the co-partner will get as a father, Malad, if he will get a property, the co-partner property as his share, in his share she will have the right. His share she will have the right.
And if at the time of death of the grandfather,
But
there is only one co-pastor, only one person will inherit.
if there is a co-partner, Malad, may kindly appreciate. If it is a co-partner, then must be some other co-partners also.
No, father and son can constitute a co-pastor.
Might not mean to
If
say.
the property is ancestral property.
Might not mean to say there is a co-partnership between the father and the son.
Yes.
Yes. In that event of the matter, if the property is inherited by the father, it will be an ancestral property. For the time being, it may be as a separate property. Once the son is born in the family, then the co-partnership will be continued with the son, for his subsequent generations after the three generations. But so far as this particular case, Your Lordship, is concerned, my Lord may kindly appreciate. And date of death is also very, very relevant. My Lord,
We will not acknowledge the date of death of 19.
no, I'm because
Death
Your
is
Lordship,
prior to 19. This is how you started the argument. Please stick to it. That admittedly death is prior to 19.
yes. One judgment, my Lord.
And prior to 1956, there is already a partition in the family. Let's acknowledge this also.
My Lord,
Prior to 1956, there is also a partition in the family.
that judgment, Your Lordship, that part, Your Lordship, I will be arguing. It appears to be contradictory.
No, appears to be then we place the facts because this is very material. That whether there was any partition
Yeah.
prior to 1956.
My Lord, the point which Your Lordship was asking, my Lord, right now, my Lord, I will be giving one judgment, my Lord, may note down it. it is case of Ashnur Singh versus Harpal Kaur, Ramadas. It is 2019 Supreme Court 3098. Lakshmi में काली सी बुलेट इसका कॉपी है ये receipt. That exactly the point your Lashuk was asking. Yeah, the issue which your Lashuk was just asking, but that is not that one.
AIR 2019-3098. ARSH Ashnur Singh. ये मंगाया इसका प्रिंट चाहिए और इसका Yes, you just argue those. You just tell us.
Allow me,
See,
Malad.
this is absolutely crucial whether there was a partition prior to 1956 or not.
Yes.
So tell us what you want to say. There was a partition or there was no partition? Mr. Sharma, what is your case? There was a partition or there was no partition?
Your Lashuk, I would like to place my plate.
Not from the plate. You show me from the findings. Why do you need to place it?
Finding.
Yes, the findings of the court.
Before Malad coming to finding, I would like to say, our case, Your Lashuk, is that there was a common ancestor, Malad, Amrit Mahto. And Malad, Amrit Mahto, Malad, had a son, Radha Mahto, and Malad, another son, Kelly.
We know the genealogy.
Yeah.
I just want to know what is your case, whether there was a partition prior to 1956 or there was no partition.
But
What is the finding?
But Malad, as per us, there was no partition. That is the reason
So
why
as
the
per
partition.
you, there was no partition, but what is the finding of the court? Has the court given any finding or
Yes.
the court has not given any
Court has
finding?
given a contradictory finding that what I am saying.
Contradictory. Where is the contradiction?
Yes.
We read the entire judgment yesterday.
Yes, I've read the entire judgment. Malad, may kindly see, Malad. Appellate Court judgment para 16.
First trial court.
Right?
Yes. There is a clear finding in para number 18, in page number 18, that there was already a partition and by virtue of this partition he acquired this.
Not kindly, but the learned trial court has presumed it.
No,
No, it is, he has presumed it, and the presumption, Your Lordship, is, presumption is on the basis of two counts. The first count, Your Lordship, is that, my lord, there is my lord, certain instances, first instances which has been taken by the, my lord, more fully discussed by the appellate court, Your Lordship, is recording of name in the, my lord, Khatiyan, in the separate name of Radhamas.
See, Mr. Sharma, please don't open Pandora box. You have to confine to the substantial question of law which has been framed. My basic and a fundamental question is that what is the finding on the point of previous partition? I will not enter into what was your case. I am looking at the finding recorded by both the courts as to whether there was a previous partition prior to 1956 or not, and how did he acquire this property? Because this property is exclusively standing in the name of Radha. Yes. So therefore, I want to know, please, but just stick to this.
Yes, I'm coming. I'm
Yes.
coming to that. So far as the finding with regard to the property in question, Your Lordship is concerned. So far as Khata number 15, 56, and 27, these are the three khatas which is involved. With respect to Khata 15 and 56, 56 in the joint name. Despite that, the suit has been taken into that.
Even if it is standing in joint name, that
But-
does not mean that there has been no partition.
That what I am saying. That what I
Therefore,
am saying.
therefore, I just want to know from you what is the finding of the court. Will you not read it, or I'll ask the amicus to read it? I just want to know what is the finding of the
With
court,
respect to my
because there is no substantial question of law and
my lord,
touching upon this
my
finding.
lord, may kindly appreciate that so far as the khata number 57 is concerned, my lord, which is in the exclusive name of the Radha Mehta, finding your lordship of the court is that, my lord, it is a separate property, and because that is the reason
Show me
why.
the finding. Show me the finding that it is a separate property and it has got nothing to do with the partition.
May kindly see page
Page
18 of the title, internal page. And that also on the wrong analysis of laws.
that is, it may be wrong, but if it is not a substantial question of law, I will not look into it. That error I will not look into.
नहीं ये तो हजूर को इसमें तो सब्सटेंशियल क्वेश्चन ऑफ लॉ है वही तो आपके राइट ऑफ डॉटर्स तो है ना
नहीं, राइट ऑफ डॉटर्स है, लेकिन प्रॉपर्टी पार्टीशन हुआ था कि नहीं हुआ था, प्रॉपर्टी का नेचर क्या है, इस पर कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है।
नहीं ठीक लेकिन इसके बावजूद भी हजूर इसको तो देखना होगा
नहीं देखेंगे, बस जितना सब्सटेंशियल क्वेश्चन ऑफ लॉ 3 दिन से सुन रहे हैं, अभी नया सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बनाएंगे, ठीक है?
लेकिन अगर कोई ऐसा
नहीं, हमको भी ऐसा
तो
नहीं,
हजूर इसको
हमको ऐसा पंडोरा बॉक्स नहीं खोलना है।
पढ़ सकता है अदरवाइज जजमेंट तो हजूर उस पॉइंट पर कैसे
कोई बात नहीं, हो जाएगा।
इसमें हजूर देखा जाए इसमें ये गए हैं इस आधार पे ये
If I may, the plaintiff number one himself has given a categorical statement कि राधा महतो और केलू महतो के बीच partition हुआ था. There is a categorical statement by plaintiff himself in his evidence that I can show, and that has come in the trial court judgment as well as the appellate court judgment. तो partition का तो कोई question ही नहीं है, because if केलू महतो has died, उसके बाद काशी महतो आए, काशी महतो से बाद की शादी हुई है.
17 से हम पढ़ना चाहिए
पैरा नंबर
पारा 17 से पेज 17 से हम पढ़ना चाहेंगे बीच में लिखा हुआ है वो देखा जाए अतः संपूर्ण संपत्ति का विभाजन उभय पक्ष को बीच में कर दिया जाए और बिलासो एवं बोनी को राधा महतो की संपत्ति में कोई अधिकार नहीं है क्योंकि राधा महतो 36 में मर गए। इस मामले में संयुक्ता की अवधारणा छीन और छीतर हो गई क्योंकि चौथी पीढ़ी द्वारा इस मुकदमे में संपत्ति के विभाजन का बात लाया गया तथा 37 के पूर्व भी स्त्रियां गोत्राज संपिताज के रूप में संपत्ति को उत्तराधिकारी होती थी। यदि पैतृक संपत्ति का बंटवारा हो चुका है अथवा पैतृक संपत्ति के अलावा कोई स्वार्जित व्यक्ति उसकी मृत्यु हो चुकी है। अनुच्छेद 36 हिंदू मुल्ला लॉ के अनुसार यहाँ पक्षों ने अपना अपना साक्ष्य दिया है। इसमें कुछ ने दावा किया है कि संयुक्त है, संपत्ति संयुक्त है, प्रतिवादी ने यह दावा किया है कि संपत्ति विभाजित है। लेकिन सब लोगों ने इस बात को स्वीकार किया है कि उभय पक्षों का धन सहन खेती बारी खान पान अलग है। राधा महतो के नाम से 57 की संपूर्ण युति दर्ज है तथा 56 की हिस्सा बराबर राधा एवं कैल के दर्ज है। सरपंच ने बिलासो एवं बौनी का कब्जा 57 के संपूर्ण पूंजी 56 पर आदि पर पाया। तदनुसार इनको संपुष्ट करते हुए चलाधिकारी ने संपुष्ट करते हुए रसीद बिलासो और बानों के काटने का आदेश दिया। काशी महतो के नाम से काटी गई रसीद को रद्द करने का आदेश दिया। हिंदू मुल्ला 43 के अनुसार विधवा का चौथा स्थान, पुत्र का 5वां स्थान तथा भाइयों का 9वां स्थान। यदि संपत्ति विभाजित है तो क्रमवार ऊपरी क्रम से लेकर निचले क्रम तक अधिकार समझा जाए। लेकिन ऊपरी क्रम में सबसे पहले जो व्यक्ति होंगे वे मृतक के संपत्ति के अधिकारी होंगे, सुदूरवर्ती नहीं होंगे अर्थात उत्तराधिकार का क्रम ऊपर से नीचे चलेगा। यहाँ मुकदमे में उपरोक्त तथ्यों के आधार पर इस निष्कर्ष को पहुँचना राधा महतो और कैल महतो के बीच संपत्ति का बंटवारा हो चुका, जिसको वादी ने स्वयं अपने पति परीक्षण की खंडी का साथ में स्वीकार किया। वादी द्वारा इस बात का उल्लेख किया जाना है कि पंचायत में राधा की मां दुखनी ने काशी को संपूर्ण संपत्ति दी इससे भी तय उजागर होता है कि राधा एवं काशी के बीच में विभाजन हो चुका। अतः बिलासो एवं बौनी संपूर्ण 57 की संपूर्ण जमीन की उत्तराधिकारी हुई और 56 की आधी जमीन की जानी। चूंकि हिंदू सक्सेशन एक्ट की धारा 14 के अनुसार जो संपत्ति किसी स्त्री द्वारा किसी भी प्रकार से अर्जित की गई है, चाहे वह अधिनियम के आने से पूर्व या बाद में की वह संपूर्ण मालिक हो, न कि प्रतिबंधित। इस प्रकार बौनी एवं बिलासों को राधा की संपत्ति पर संपूर्ण अधिकार ने 56 में, क्योंकि 56 में उसके नाम से रसीद कटने लगी, वह संपत्ति के दखल में पाई। 56 के पूर्व बिलासों में बौनी हिंदू विधि के अनुच्छेद 67 के अनुसार अवतारी हुई और 37 के बाद प्रतिबंधित मालिक लिमिटेड ऑनर हुई और 56 के बाद उसमें पूर्ण मालिक। अतः विवादवश को विरोध नहीं किया। ये सब जो लॉ के अगेंस्ट है फाइंडिंग, ये सब वीडियो को सोच करके ही दे रहे हैं, वोटर को सोच कर कैसे होगा? वोटर को सोच के ही दे रहे हैं। अपील कोर्ट का हम निकाल शेयर भी इनका एलोकेशन प्रॉपर नहीं है, वो भी प्रॉपर नहीं है, शेयर एलोकेशन भी प्रॉपर नहीं है। पूरा यहाँ तक कि काशी महतो के कुल संपत्ति
नहीं, ये आप जो है ना, ये बीच में आधा ही छोड़ो।
अच्छा पूरा
1956 के पूर्व
को निर्णय किया जाता है, निष्कर्ष दिया जाता है कि खाता 57 के संपूर्ण जमीन आधी जमीन को प्रतिवादी के संयुक्त नहीं है, बल्कि राधा महतो की पुत्रियां बिलासो एवं बौनी की संपत्ति तथा उत्तराधिकारी के रूप में पुरानी हिंदू विधि के अनुसार प्राप्त हुई है, तथा उत्तरजैविता के आधार पर काशी महतो और राधा महतो की संपत्ति प्राप्त नहीं हुई, क्योंकि संपत्ति राधा महतो और काशी महतो के बीच विभाजित हो चुकी। वह संयुक्त परिवार की हिंदू संपत्ति नहीं। इसमें इनका फाइंडिंग यह है और अपील कोर्ट का फाइंडिंग हम दिखाते हैं।
चेंबर में ब्रीफिंग नहीं होता है क्या? होता है ना? यहाँ पे डिस्कशन मत करिए प्लीज। आपने चेंबर में ब्रीफ किया होगा ना सीए को कि देयर इज अ कॉन्ट्रडिक्शन या जो भी आप बोल रहे थे 10:30 बजे। ऐसे नहीं, इस तरह से नहीं होता। इतना पेशेंटली सुन रहे इसका मतलब ये नहीं है कि यहाँ पर आप ड्राइंग रूम बना लीजिए डिस्कशन कर रहे हैं। प्लीज डोंट डू दैट। वी आर लिसनिंग इट वेरी वेरी केयरफुली और रिपीट नहीं करिए और अपना चीज़ को ट्रायल कोर्ट के जजमेंट्स में आपको जो जो फाइंडिंग प्लेस करना है आप सब प्लेस कर लीजिए एट अ टाइम।
इनका इसमें जो फाइंडिंग जो जिस पॉइंट पर जो पूछ रहे थे तो हम दिखा दें।
तो हम लोग कल देखें हैं, वो तो हम लोग कल देखें,
अभी हमने दिखाया,
कल पूरा ही पढ़े थे, कल यही फाइंडिंग हम लोग देखे हैं और इसी को मार्क किए।
अब इसमें हजूर इसमें हम ये कहना चाहते हैं कि आधा संपत्ति पे और 57 का पूरा संपत्ति पर ये एक तरीके से ट्रायल कोर्ट में निकले, अपील कोर्ट भी उसी पे चले, लेकिन जो डिक्री की उसमें इरेगुलरिटी, इस सेंस में इरेगुलरिटी है कि अच्छा इसमें एक फैक्ट और एडिशनल इम्पोर्टेंट है कि चोलाराम महतो जो है वो चोलाराम महतो और उनकी बहन वो सेकेंड वाइफ से ही इन लोग का भी बर्थ हुआ है, उसमें इनको भी राइट दे दिए। बौनी को तो कोई राइट नहीं दिए। एक्चुअली ये प्रॉपर्टी जो अगर है भी, अगर 57 का प्रॉपर्टी खाता 57 का और आधा अगर 56 का जो प्रॉपर्टी है उसमें तो बौनी का राइट होगा, चोलाराम का तो नहीं होगा। और अगर चोलाराम का हो भी रहा है राइट तो सेल डीड के बुनियाद पे हो रहा है, जो कि अंडर क्वेश्चन है। तो आखिर 56 का जो हक है वो चोलाराम को नहीं दे सकते हैं, या वो इनका नहीं होगा, चोलाराम का नहीं होगा तो बौनी का होगा। ये भी एक इरेगुलरिटी है इसमें, इस जजमेंट में।
We are looking at only खाता नंबर 57।
नहीं 57 में तो सेल्डिड है, चूंकि सेल्डिड है इनके नाम से, चोलाराम महतो के नाम से, जो कि हमारे स्टेप्स उनको सेल्डिड के आधार पर राइट देते हैं। वो इनहेरिटेंस के आधार पर नहीं दे रहे। और ये बात
Who has executed the sale deed?
sale deed has been executed by the daughters.
By daughters.
Daughters. तो अगर और ये खुद भी मान रहे हैं कि मेरा हक नहीं, डॉटर्स का हक है और डॉटर्स ने ही सेल डीड डिस्प्यूट किया है, इसके आधार पर ये चीज पर हमारा हक नहीं मान रहे हैं। लेकिन जो डॉटर्स का राइट अगर 57 पर ये मान रहे हैं और 56 पर ये आधा मान रहे हैं, तो उस हिसाब से तो डिग्री गलत है। ये बात हम कहना चाहते हैं। अब रह गया जैसे कि अगर एपेलेट कोर्ट कह रहे हैं कि पार्टीशन का कोई प्रूफ नहीं है, अगर कोई प्रूफ जब पार्टीशन का नहीं है तो एक तरफ तो कह रहे हैं कि नहीं पार्टीशन इसको विभाजित माना जाएगा, दूसरा कह रहे हैं कि
trial court. What is the finding of the appellate court?
Yes.
Appellate court has reversed the finding. Has the appellate court reversed the finding of the trial court on the point of previous partition?
नहीं, इस पॉइंट पर तो रिवर्स नहीं किए हैं, लेकिन उनका एक तो कहना है कि कोई पार्टीशन का कोई प्रूफ नहीं है, ऐसा बोले।
प्रूफ तो कोई जरूरी थोड़ी है, कोई
तो
डॉक्यूमेंट बन जाए।
बिना प्रूफ के कैसे आप?
बिना प्रूफ के नहीं, these are the circumstances and all the evidences.
वही हम
Your
कह रहे हैं।
PW himself is saying that there was a partition
वही
between
बात
them.
हुजूर को हम कह रहे हैं कि अगर एक तो इंस्टेंस खाली कंसीडर करके आप जजमेंट नहीं ना करेंगे,
ऐसा
आप एक इंस्टेंस
Mr. Sharma,
कंसीडर।
that is not the substantial question of law. Please do not move beyond it. Otherwise ये डिस्कशन करेंगे ना तो हिंदू सक्सेशन एक्ट का डिस्कशन 1956 से पहले से लेकर अभी तक चल रहा है और इतना कॉन्फ्लिक्टिंग और इतना कॉन्ट्राडिक्टरी जजमेंट्स जो अपरेंटली लगता है, ठीक है, तो ये तो कभी नहीं खत्म होगा, 2-3 साल चलते रहेगा केस। तो इसीलिए जो सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है, प्लीज फोकस ऑन दैट and now there is a concurrent finding that there was a previous partition in connection with the property. Now you tell us what will be the status of the daughter if there is a previous partition, what will be the nature of the property if there is a previous partition. इतना ही तो है।
हाँ नहीं ठीक है, हमारा तो इसमें हजूर इसमें सिर्फ इतना ही करना है कि जो आधार ही लिख रहे हैं और जो शास्त्रिक लॉ के आधार पर जो दे रहे हैं उसके आधार पर भी इनको राइट नहीं होगा, दैट व्हाट, इसलिए हम ये फाइंडिंग दिखा रहे हैं। इसमें हजूर इसमें देखा जाए, इसमें मुल्ला को थोड़ा सा
क्या कौन सा पेज?
बता। हम जो प्लेस करना चाहते थे हजूर वो 139 बॉटम में 139 लिखा है। 20th
This 139.
142 बोल रहे हैं।
The
हमारे
edition
किताब में
has
139
new book, there will be 142 in edition. Order of succession amongst subindas, chapter 4.
39 20th एडिशन हजूर हम प्लेस करें।
Order of succession among Sapinda.
Yes, और page 143 के ऊपर लिखा हुआ है.
I have 137. This is 21st edition.
I have 21st edition 2010.
Page number?
Page number 142.
Widow.
The remarriage of a widow did my lord find. Though legalized by Hindu Widows Remarriage Act 1856, divorced the estate inherited by her from the deceased husband. By her second marriage, she forfeits the interest taken by her in her husband's estate, and it passes to the next heirs of her husband as if she were dead. Pandurang versus Sindhu, the High Court of Bombay explained the effect of Section 2 of the Act read with Section 14 of the Hindu Succession. The reason for the rule laid down in Section 2 is that a widow succeeds as a surviving half of her husband and she ceases to be so on witnesses. However, a widow does not by remarriage loses her right to succeed to the estate of her son. So far as the son, your lordship, is concerned, she will be. But so far as the husband, your lordship, is concerned, that she will forfeit the right. In this particular case, my lord, the facts of the case, your lordship, is that the Radha Mahato, Sohagi is the widow of the Radha Mahato. And so, moment, my lord, she remarried, then, my lord, the property will go to the reverse husband.
Once she remarried,
My lord.
right? Upon remarriage, she will not have any right. यहाँ तक आप stop करें.
नहीं,
उसका property कहाँ जाएगी वो अभी decide करो.
हाँ, नहीं, ठीक, ठीक,
एक बार शादी होने के बाद,
ठीक,
she has no right over it.
नहीं ठीक, लेकिन जब कानून और शास्त्रीय लाभ के हिसाब से अगर वो विडो अगर है, जैसे जिस समय जब तक शादी नहीं हुआ तब तक तो विडो थी, तो जैसे जब वो विडो जब थी जैसे, तो राइट उसी को होगा, इवन एज पर द शास्त्रिक राइट ऑल्सो।
राइट, उसके बाद शादी हो
नहीं,
गई,
जैसे ही शादी हो गई वो भी काशी महतो से, इस पर्टिकुलर केस में काशी महतो से शादी हुई, जैसे ही शादी होगी वैसे अब उसके बाद ये डॉटर्स को नहीं जाएगा, उसका रिवर्स
नहीं, वो हम लोग डिसाइड करें किसको जाएगा, लेकिन उसको नहीं जाएगा विडो को, ये बात है
ना, विडो को तो
इसमें तो कोई डिस्प्यूट ही
कोई
नहीं,
डिस्प्यूट ही नहीं।
द विडो विल हैव नो राइट।
और उस पर्टिकुलर केस में जब ये कानून के हिसाब से, शास्त्रिक लाइट के हिसाब से भी जो विडो के बाद ये रिवर्सनेस को जा रहा,
विडो को नहीं मिलेगा, यही तक अभी तक तय।
नहीं ठीक,
अब शास्त्रिक लॉ तो तब लगेगा जब हमारे
नहीं,
बाकी
तो
लॉ या बाकी जुडिशियल प्रोनाउंसमेंट से कवर्ड नहीं है।
अगर हजूर जो
आपकी तरह विद्वान हम नहीं,
हम बता रहे हैं इसमें, इसलिए हम कह रहे हैं इसमें कि अगर हुजूर अगर इसको कमेंट्रीज वगैरह अगर नहीं देखा जाएगा, या अगर अरुणाचला का जजमेंट हजूर नहीं देखा जाएगा, या कोई भी
आप
अदर,
कर रहे हैं फुल टेक्स्ट 3 बार पढ़,
नहीं हम दूसरी बात कह रहे हैं,
3 बार आई हैव रेड दैट जजमेंट फुल टेक्स्ट 3 टाइम्स,
हम दूसरी बात कह रहे
देयर इज सो मच इनटू इट।
उस तब अगर वैसा अगर होगा तब तो डॉटर्स को राइट ही नहीं होगा। अगर जो भी इनको जो राइट होगा ये अंडर द ओल्ड मिताक्षरा लॉ में ही हो सकता है, और अगर होगा कि नहीं होगा इस चीज को भी हम लोग को इसमें हजूर इस केस में देखना है। लेकिन इस केस का फैक्ट्स अरुणाचला केस से भी डिफरेंट है, और अदर आई वुड से इट इज डिफिकल्ट, इसलिए कि इस केस में रिमैरेज का इशू अरुणाचला केस में नहीं है, इवन बॉम्बे के केस में भी नहीं, और ये छत्तीसगढ़ वाला केस में नहीं। It is perhaps a very unique case in that regard. इस सेंस में इस पॉइंट को भी बिना इसको कंसीडर किए ट्रायल कोर्ट ने भी नहीं देखा, अपील कोर्ट ने भी नहीं देखा इस पॉइंट। रिमैरेज का इशू नहीं
2008 से चल रहा है
जी,
इसीलिए 2008 से चल रहा है क्योंकि यूनिक केस है।
हाँ ये यूनिक केस,
बस अब बहस करिए, यूनिक केस हम डिसाइड करेंगे, अब सुप्रीम कोर्ट से सेटल कराइएगा।
नहीं ठीक। और हम इसमें 2-4-5 जजमेंट फिर भी काउंसिल वगैरह का भी देखें, वो यूज इस लाइन पे है कि विडो को ही राइट, जो कि
विडो को राइट खत्म हो गया बिकॉज़ शी गॉट रीमैरिड।
जब ऐसे भी हजूर पुराना वाला जो कि लॉ है, जो मिताक्षरा लॉ है, हिंदू सक्सेशन एक्ट का उसी का ही बहुत सा रिफ्लेक्शन है, जो कि वो सब पिंडाज कैसे होगा, कौन होगा, वो सब भी पढ़ के सुना देते हैं। हजूर भी उसको जान रही है, इसमें नहीं। लेकिन जब एक अगर अवेलेबल है तो दूसरा में जाएगा ही नहीं। That's right. तो एक बार अगर विडो अवेलेबल थी, उसको मिला और विडो ने रिमैर नहीं कर दी तो बात अलग था।
You see, forfeit हो जाएगा उसका
Forfeit
पूरा का पूरा estate, she will be divested of the estate inherited by her.
हाँ, तो जब
whatever has devolved upon her,
हाँ
that will be taken up.
टेकन अवे, तो जब एक बार टेकन अवे हो गया तो उसके
Taken
बाद
away हो गया तो it comes back to the same.
comes back to the reverser.
Then the next line may be seen, and it passes to the next heirs of her husband.
हाँ, husband का
Next
तो हम लोग है
heirs
ना।
is the daughters, because fifth in the line is daughters.
No.
After widow comes daughter.
She is the daughter of Radha Mahato. Please understand what I
Yes.
say. And here in this case, my lord, the brother himself is there. Brother is
comes
himself
ninth
there,
in the
and
string.
not only that, the peculiar circumstance here is that the widow has remarried him, my lord. यहाँ पे तो रिवर्सन में नहीं होने का सवाल ही नहीं है। अगर कोई और बात होती, कोई और कोई केस होता, तो उस केस में रिवर्सन में वाले नहीं होता, लेकिन इसमें होगा, इसमें होगा। इसलिए उस पर्टिकुलर एस्पेक्ट को कंसीडर करके ही इसमें डॉटर का राइट को इसको
So the mother will get remarried and deprive her own daughters, and then the entire property will go to the brother-in-law's family.
My lord, may kindly appreciate.
Yes,
This is
this
not
is
a
what
case.
you are
This is
proposing.
not a case of depriving. Rather, my lord, when my lord she married to my lord the Kasim Mahto, my lord she got protected, my lord. The
She
daughters got protected.
You want to? The daughters got protected.
Yes,
How?
because of my lord the father has already died.
Now, how the protection? What is the consequence of this protection? That they will get no property.
That is a different.
That is the consequence of protection.
My lord, may kindly.
Daughters were otherwise also protected in the family. As long as their mother was there, they were protected.
But the mother, my lord, remarried.
That's right.
And for further protection,
So,
she married. My lord.
daughters को
That I want to say.
daughters को सड़क पे छोड़ के she will die. They will have no right.
Daughters का राइट तो हजूर जब विडो है ही तो उसके बाद ही ना होगा।
विडो का रीमैरिज होने के बाद
हाँ।
की बात कर रहे हैं।
जब विडो के रीमैरिज होने द मोमेंट मतलब अगर विडो का राइट अगर रीमैरिज हो जाता है तो इट विल नॉट गो टू डॉटर्स को नहीं जाएगा।
This is your entire case.
यही मेरा केस है। This is my case.
हो गया? अब जजमेंट दिखाइए। कौन सा जजमेंट आप साइड करना चाहते हैं? इसका पेज नंबर 142 सभी जी, ये पेज नंबर 142 से लेकर यहाँ तक थोड़ा सा फोटो कॉपी कर लेंगे और ये वाला एडिशन यहाँ रखना। Yes, please. What all judgments do you want to cite?
Yes.
एक बार आप हमको लिस्ट दे दीजिए, उसके बाद एक के बाद आप एक लिस्ट मुझे दे दीजिए कौन सा जजमेंट आप साइड करें। आई एम जस्ट नोटिंग। एक चीज मिस्टर शर्मा आपको बता, एक चीज आपको बहुत ही रिस्पॉन्सिबिलिटी के साथ बताना। इन सेकेंड अपील, if I decide a substantial question of law and if it is not set aside, I will follow it till it is set aside. So be very very careful. आपको दोनों तरफ से अपील होना है, कभी लड़की की तरफ से कभी भाई की तरफ से, तो ऐसा काम बिल्कुल ना करें
ना कभी नहीं करेंगे
कि कुछ गलत लॉ डिसाइड
कभी
हो,
नहीं।
क्योंकि यहाँ का हर एक लिटिगेशन सुप्रीम कोर्ट नहीं जाता।
हम दूसरी बात कर रहे थे, कम से कम
कि आपको ऐसा ना बोलना पड़े कि हम जो उसमें बहस किए थे तो उसको आप लाके बेंच पे रखो।
ऐसा कभी नहीं,
हाँ, बस ठीक है।
कभी नहीं हुआ। इसका कारण है जैसे I know that
Writ petition नहीं है इसमें।
High Court is a court of record.
Not only court of
Where I'm
record,
conscious of
substantial question of law is decided in a high court. It is binding on the judge also. यहाँ पर facts and circumstances में बोलकर हम नहीं निकल पाएंगे, रीट में निकल जाते हैं, इसमें नहीं निकलते।
नहीं इसमें, लेकिन एक चीज को हुजूर को इसमें हमारे समझ से बहुत हमले हम कह रहे हैं कि इसको देखना,
हम देखेंगे ना।
हाँ इसलिए देखना,
आपको कोई डाउट?
नहीं हम दूसरी बात कर
हमको
रहे
जितना समझ आएगा।
हैं। अरुणाचला जजमेंट जो है it is being relied upon the other side.
अब आप अपना जजमेंट्स बताइए, कौन सा जजमेंट आप रिलाय करें?
एक तो जजमेंट हमने ऑलरेडी दिया हुआ है,
बॉम्बे
2024 SCC ऑनलाइन बॉम्बे
2024 SCC ऑनलाइन बॉम्बे
354
3541। इसमें
राधा
दो
भाई
इम्पोर्टेंट
वाला
फीचर थे। इट इज रिलेटिंग टू
Your Worship, in that a widow and daughter both were there, and she had not remarried.
and it was co-pastoral property which was devolving upon the
But anyway, this point of law has been decided in this particular case. So इसमें अरुणाचला जजमेंट को भी इन्होंने कंसीडर किया और सुप्रीम कोर्ट का भी जजमेंट इसमें इन्होंने इस केस में किया है। इसलिए इस पॉइंट को दिखाना चाहेंगे। इसके अलावा हजूर एक जजमेंट है छत्तीसगढ़ हाई कोर्ट का, ये 2025 एससीसी ऑनलाइन छत्तीसगढ़ 1013
SCC ऑनलाइन
एससीसी ऑनलाइन छत्तीसगढ़ 1013
1013
1001
10
100 1000
10,013
10,000 ये इसके अलावा हम लोग 2022 मालूम 11 एससीसी
2022 SCC पेज नंबर
520
5.
Arunachala judgment is being referred by other side also. And, in judgments also might not be find the reference. So this discussion is required.
इसमें तो सब आपने छत्तीसगढ़ वाला जजमेंट दिए हैं, इसमें तो सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं पूछता।
छत्तीसगढ़ वाला।
देखिए क्या है इसका, इस केस से क्या नहीं
नहीं इसमें वही सब डिसाइड हुआ है।
नहीं सब्सटैंशियल क्वेश्चन ऑफ लॉ देखिए ना क्या है,
इसमें लेकिन पॉइंट्स सब वही सब।
बहुत सारा डिस्कशन से नहीं होगा।
नहीं, और
Substantial question of law होगा।
इसमें भी इन्होंने संस्कृत लॉ वगैरह को कंसीडर किया। लेकिन ये सारे जितने जजमेंट्स हैं इसमें कोई मेरे विडो मैरिज का इशू नहीं था। विडो मैरिज इज एन इशू इन्वॉल्व इन दिस केस। इस पर्टिकुलर केस में ये एक इसको कंसीडर करना पड़ेगा कि अगर जो टेबल है भी, अगर सापिंडस का टेबल अगर है, अगर उसमें अगर मान लीजिए अगर विडो का पोजीशन और डॉटर का पोजीशन अगर है भी, तो उसके आधार पर इनको क्या राइट होगा, एक चीज इसको भी देखना होगा। दूसरा, विडो ने जब रीमैरेज कर ली तो उस पर्टिकुलर केस में इसमें ये जो प्रॉपर्टी है इट विल गो टू द रिवर्सनर, डॉटर को राइट नहीं होगा। ये सारे जितने केसेस हैं, जो केसेस हुजूर को हम रेफर कर रहे हैं, इसमें किसी भी का भी विडो का केस नहीं।
Just a moment. You see this judgment of Bilaspur and you read para number 29. 29, the last page.
20
29.
29 हाँ, ये बात ये इन्होंने इस केस में दूसरे एंगल से गए हैं। इस केस में एक सन था, इसके चलते ये कंसीडर कर रहे थे। हमारा केस में सन भी नहीं है, सिर्फ डॉटर है, और विडो है जो कि इस केस में नहीं है। इस पर्टिकुलर केस में ये एक बहुत रेलेवेंट पॉइंट होगा कि विडो को क्या राइट था, और अगर विडो को राइट होगा तो विडो को रिमैरेज होने के बाद जब एक बार उसका राइट हो, जब अगर वो तो रिवर्सनस को जाएगा कि डॉटर्स को जाएगा।
She will be completely divested.
Completely
as if she
divested.
never existed.
हाँ, तो
As if she never existed.
as if never existed. तो जब उसका what about her rights?
Her right, she will have no right on the throne.
No.
जैसे कि मृत्यु में सब चीज छोड़ के जाना पड़ता है,
ठीक।
वैसे ही विडो रिमैरेज में सब चीज छोड़ के जाना।
लेकिन प्रॉपर्टी तो क्या नाम है उनके हस्बैंड को जाएगा, क्योंकि उनके ब्रदर है।
नहीं जाएगा।
नहीं जाएगा।
नहीं।
जाएगा।
I don't think अभी तक so far.
नहीं जाएगा। रिवर्सनस का जब राइट है, रिवर्सनस का राइट रहेगा। इसके अलावा कुछ पुराने जजमेंट हैं जो हमने पहले
You just cite any judgment as to what would be the nature of property post partition.
उसको तो दिया आपने।
इसमें
वो अभी तो जजमेंट हमने दिया उसको।
बॉम्बे वाला
नहीं, बॉम्बे वाला भी और ये वाला भी।
छत्तीसगढ़
सुप्रीम कोर्ट दिया आपने।
ये
इसके अलावा
2020 वाला जजमेंट असूर सिंह।
अच्छा, इसके अलावा श्याम नारायण प्रसाद का जजमेंट हम पहले उस केस में दिया।
उस केस से नहीं, उस केस का जजमेंट उस केस से लगी। अभी आप हमको बताइए
उसका साइटेशन मुझे है तो वही जजमेंट इसका, लेकिन इससे हम अभी नहीं। इसके अलावा एक जजमेंट है 1976 सुप्रीम कोर्ट,
which has been considered in Chhattisgarh judgment.
हाँ सब ये सारे, और अरुणाचला भी कंसिडर कर रहे हैं, ये सारे कंसिडर कर रहे हैं। एक जजमेंट है 76 का, 76 वॉल्यूम 4 SCC 674।
1976 volume 4 SCC 674।
ये जजमेंट है इस पॉइंट पे है कि अगर एक बार विडो को अगर रिमैरेज के बाद भी सन से डाइवर्स नहीं हो, लेकिन हस्बैंड से हो जाए,
सन के थ्रू अगर वो इनहेरिट कर रही है,
नहीं अगर वो रिमैरेज भी करेगी तो
रिमैरेज भी करेगी, अगर सन के थ्रू इनहेरिट कर रही
हाँ,
है,
तो वो-
सपोज देयर इज अ सेल्फ एक्वायर्ड प्रॉपर्टी ऑफ द सन
यस
and if he dies
यस
and she inherits some property from that,
यस
then she will not be divorced.
यस दैट व्हाट इज इट।
That's okay.
बट आई कुड नॉट फाइंड एनी जजमेंट, जो जजमेंट है सो मुला में और या एक्ट में। एक्ट तो कह रहा है कि हस्बैंड से होगा ही नहीं। हस्बैंड से एक बार आप अगर मैरिज कर लेते हैं तो टोटल डाइवोर्स हो जाएगा, एज इफ यू डाई।
Yes.
डाई। और लेकिन व्हाट अबाउट द प्रॉपर्टी, नेचर ऑफ प्रॉपर्टी? तो एज पर द मुला
Completely divested means whatever you have received, you have to leave it in the family and go.
यस, और उस कंडीशन में एज पर द मुला इट विल गो टू द रिवर्स नाउ, नॉट टू डॉटर्स। मुला तो कह रहे हैं, हम तो अभी हजूर को पढ़ के सुनाए, उसमें कुछ प्रीवी काउंसिल का जजमेंट है जो कि हम इसको डाउनलोड नहीं कर पाए, लेकिन हम इसमें प्रीवी काउंसिल सर्च किए थे तो कुछ हमको एक ILR का जजमेंट 1905 का और कुछ प्रीवी काउंसिल का जजमेंट जो है उसको हम डाउनलोड करके देते हैं। श्याम प्रसाद उस पॉइंट पे है कि कोपाशनरी वगैरह के पॉइंट पे है, प्लस अगर सन का बर्थ हो जाता है तो उस कंडीशन में ये प्रॉपर्टी जो है सो अगर इवन इफ अगर इनहेरिटेंस बाय फादर है तो भी ये प्रॉपर्टी कंटिन्यू करेगा एज ए कोपाशनरी। उस पॉइंट पे नेचर ऑफ प्रॉपर्टी के पॉइंट पे इस पर्टिकुलर केस में जो हमारा केस है, जो प्लीडेड केस है, कि अमृत महतो का ही एक्चुअल में ये प्रॉपर्टी है जो कि इन लोग दोनों के नाम से एक्चुअल में उपलब्ध है। उसमें से कुछ ज्वाइंट है, कुछ इनके सेपरेट है, लेकिन कोई पार्टीशन बाय मीट्स एंड बाउंड नहीं हुआ। उसमें एक जजमेंट है जिसको हम पहले भी उसको दिए थे। पटना हाई कोर्ट का एक जजमेंट हम पहले भी एक दूसरे केस में हुए को दिए हैं, 88 SCC ऑनलाइन 1989 PSJR है, जो कि कहता है कि
88 SCC online.
SCC ऑनलाइन पटना 3 1989 PSJR।
Is it full bench?
ये जलेश्वर मिस्त्री है।
This covers your case.
नहीं, ये वाला इस पॉइंट पे है ये रेवेन्यू रिकॉर्ड में राइट होने से भी पार्टीशन नहीं होगा, उसको आप प्रिज्यूम आप
पार्टीशन हुआ है कि नहीं ये तो क्वेश्चन ही नहीं है। पार्टीशन हुआ है, देयर इज अ बाइंडिंग, दैट्स बाइंडिंग।
नहीं, हम इसलिए इसको दिखाना चाहते हैं क्योंकि एक प्लॉट पर आप 56 पर आप
नहीं,
पार्टीशन दे रहे
that's not a
हैं,
question.
दूसरे प्लॉट पर आप सीधा बोल दिए पार्टीशन नहीं होगा, दैट फाइंडिंग इज कॉन्ट्राडिक्टरी। उस पॉइंट पर भी तो आखिर इनका एलोकेशन ऑफ शेयर सही है ना, इनका ये भी सही नहीं है, एलोकेशन ऑफ शेयर भी सही नहीं है। दूसरा एक पॉइंट और भी अंडर कंसिडरेशन होगा, क्योंकि
आप अरुणाचला वाला जजमेंट है आपके पास?
कौन वाला?
अरुणाचला वाला
अरुणाचल वाला।
2022 पढ़िए, पैरा 50 51 पढ़िए,
वाला नंबर
50 and 51।
फिफ्टी 50
Five.
50 1929 का एक्ट को भी रेफर किए हैं, उसमें 1928 का एक्ट लेकिन हमें मिला नहीं, आई फाइंड इट, आई कुड नॉट फाइंड इट।
Para 50 पढ़िए। Yes, madam, you have cited this judgment. You read para 50 again.
Para 50. The Hindu law of inheritance was the earliest 1929 was the earliest statutory legislation which brought the Hindu females into the scheme of inheritance. The 1929 Act introduced certain female statutory heirs which were already recognized by the Madras Code, that is the son's daughter, daughter's daughter, sister and sister's son, in the order so specified, without making any modification in the fundamental concepts underlying the textual Hindu law relating to inheritance. Only difference being that while before the Act they succeeded as bandhus, under the Act they inherited as Gotra Sapindas. Para 51, the Mitakshara law also recognizes inheritance by succession, but only to the property separately owned by an individual, male or female. Females are included as heirs to this kind of property by Mitakshara law. Before the Hindu Law of Inheritance Amendment Act 1929, the Bengal, Banaras and Mithila sub-schools of Mitakshara recognized only 5 female relations as being entitled to inherit, namely widow, daughter, mother, paternal grandmother and paternal great-grandmother. The Madras sub-school recognized the heritable capacity of a larger number of female heirs, that is, of the son's daughter, daughter's daughter and the sister as heirs who are expressly named as heirs in the Hindu Law of Inheritance Amendment Act 1929. The son's daughter and the daughter's daughter ranked as bandhus in Bombay and Madras. The Bombay school, which is most liberal to women, recognized a number of other female heirs,
That's
including.
right. So now, under this Act of 1929, is it applicable in this Act or it is not? Applicable. You cannot say that it is not applicable, right? It recognizes widow, daughter, mother. Widow, if the widow is there, she has got the right. If the widow is not there, by virtue of marriage or by virtue of death or whatever be the reason, then under such circumstances, there is no other male heir in the family post partition. Then under such circumstances, the property will go to the widow, to the daughter.
Lord, मैं कहिए कुछ। The Act
This is what I am thinking.
but Act came in 1929,
Yes.
and the my lord, the Radha Mahto died in 1936.
Yes.
At the 11th point of time, there was a widow already there. The question your lordship is,
No, therefore, post 1929.
Post
We are in post 1929 era. Even if we take your case that he died in 1936, why should we ignore 1929 Act?
then,
Why are we stuck to 1937 Act?
my lord, I'm stuck to 1937 Act itself, because my lord, in the year 1937, the right was given, my lord, some right was given to my lord, widows.
Yes.
And my lord, later on, my lord, in 1956, the right matured.
So, on the face of this finding of the Honorable Supreme Court, just staring at us, a clear finding.
No,
They got
there-
it as late as 2022, right? And it is not your case that this is otherwise not applicable. Then why should not we be guided by this? Is there any reason to ignore para 50 and 51?
No. My case, Your Lordship, so far as this particular case, Your Lordship, is concerned. In this case, Your Lordship, is not akin to my lord this Arunachala case. That is my first submission.
How distinguished this?
Yes.
Distinguished this judgment.
Yes. Your Lordship, may kindly see what are the facts of this case. Suit for partition was filed by Thangamal, daughter of Ramaswamy. I am reading page 3, para 3. Did my lord find?
Yes.
Suit for partition was filed by Thangamal, daughter of Ramaswamy Gounder, claiming one-fifth share in the suit property on allegation that the plaintiff and defendants number 5 and 6, namely Ilamal and Lalamal and one Renamal, are sisters of Gurutha
You
Gounder.
can straight away come to para 6.
It is undisputed fact between the parties that the property in question in the suit property was independently purchased by Maratha Gounder in the 1938 through the process of court succession. That is also not the case here.
That's right.
It is not the case here. Our case, Your Lordship, is that it is the property of my lord the Amrit Mahato and was recorded in the, some of the properties was recorded in one name of his one son and some of the properties was recorded
We
in
are looking at post partition scenario. We are looking at post partitions. There was a partition in the family. We are looking at post partition scenario. Here it was a self-acquired property because he purchased it by auction.
separate.
Separate property. So property acquired through partition, does it constitute a separate property? Will be the court issue involved in this case.
My lord, it will depend upon the facts and circumstances of each and every case.
So I just want to know what is your case.
But so far as my case, Your Lordship, is concerned,
It will constitute a separate property or it will not constitute a separate.
my case, Your Lordship, is that it is not a separate property, it is rather a joint property. Whether it is in name of the Radha Mahato or in the name of my lord, his brother Kailu, or whether exclusively or joint. All properties, Your Lordship, is of my lord, joint in nature.
There is a finding that there was a partition.
My lord, the
Post partition, what will be the nature of it?
my lord,
68
may
answers
so far as the
in para 68.
so far as the
Categorically
finding, Your Lordship,
answers
so
it.
far as the finding with regard to partition, Your Lordship, my humble submission is that it is contradictory. At one hand, with some of the khatas, my lord, the right is being given, and for the others khatas, my lord, having though it is in the exclusive name, my lord, that is being left out. So even on the point of partition, Your Lordship, the finding does not is contradictory. That's what I want to say.
Share right of a widow or daughter to inherit the self-acquired property or share received in partition of a co-partitionary property of a Hindu male dying intestate is well recognized not only under the old Hindu customary law but also by various judicial pronouncements.
You read further.
Para
Property.
68.
No, you continue reading.
And thus, our answer to the question 1 and 2 are as under. If a property of a male Hindu dying intestate is a self-acquired property or obtained in partition of a co-partitionary or a family property, the same would devolve by inheritance and not by survivorship, and a daughter of such a male Hindu would be entitled to inherit such property in reference to other collaterals. This is exactly my case, Your Ladyship.
My lord, so far as this particular case, Your Lordship, is the Ranachala case, Your Lordship, is, here there was no, my lord, case of remarriage. Here,
It makes no difference.
my lord, no, it will make difference. My lord, may kindly appreciate. Had the widow not married, then my lord, the situation would have been otherwise. Once the widow remarried, my lord, then my lord, the property will go to the reverseness, my lord, of her husband, my lord, heirs of her husband, not to the daughters. That what is the old Shastric law also called, that what has been relied upon. After all, my lord, your
So
lordship,
had there been no widow, the property will devolve.
had there been no widow,
The property will devolve as per the upon the daughters.
that could have been case. That could have been case.
But
if
since
suppose-
there was a widow,
and the widow remarried, that what is the
that's
difference?
right. Since there was a widow
The widow-
and she remarried,
Remarried
therefore the property will now devolve in a different manner.
will default in a different manner. And Arunachala case, your lordship, is not on this point. So far as my lord, your lordship may
You
kindly
see, whenever there are discussions on findings of in the judgment of the Honorable Supreme Court,
my-
even an auditor is binding on us.
No.
I hope you are
I
aware
very
of
humbly,
this.
I very humbly want
Even
to say.
the discussions, the findings, even those are binding on us, even if they may not be directly in issue before the Honorable
But not-
Supreme
but
Court.
not
Even
like-
an auditor, this is what I am saying, there is a judicial pronouncement
Yes.
to this effect, that even an auditor of the Honorable Supreme Court is binding on us.
My lord, I would humbly, very humbly want to disagree. What is binding is the ratio dissent. It is not the
Certainly.
not the
No,
observations are never binding.
The
Never
court
binding.
is discussing and coming to a finding that this is the law and this is how it is. Maybe that it was not directly in issue.
I
because
will give a direct
the entire background of the Hindu Succession
My
Act,
lord,
right of women to property, has been discussed.
I will give a direct judgment, my lord, on this point that what is binding. Actually, my
Yes.
lord, the binding, your lordship, is only the result and then not the observation.
The ratio, that is the ratio.
No, that is not the ratio. Lordship, very humbly want to disagree, my lord. In the Arunachala case, my lord, the
It
issue.
will be difficult for me to say that Arunachala case is. I will not be able to distinguish it in the manner you are expecting me to do it.
My lord, Arunachala case, your lordship, the right of separate property of a person.
The court also says that the separate property or the property acquired by way of partition.
I agree to that. To that extent, my lord, even your lordship, I agree to that extent, my lord. Then, my lord, the deviation starts from there, your lordship. Deviation starts from there. My lord, may kindly appreciate. Once the widow, your lordship, has come into picture, and the moment, my lord, in that Arunachala case, my lord, the facts of the Arunachala case is there was no widow, there was only a daughter.
So that is the distinguishing.
That is the distinguishing feature. That is one point. Second point, your lordship, is that in particular case, in this particular case, my lord, there is a widow, and my lord, the widow got remarried. That what is the distinguishing feature? That on the pretext of Arunachala case, your lordship, this case cannot be decided. This case cannot be decided. And so far as, my lord, the observations made by, my lord, the Honorable Apex Court, your lordship, or any court, your lordship, what is binding is the, my lord, the ratio dissenti, not the observations, your lordship. My lord, Honorable Apex Court, or even, my lord, the Honorable High Court, my lord considers several things, my lord. Then what actually is ultimately decided, my lord, it depends upon two things, my lord. First, what is the facts of a case? If the facts are not alike, even if the law has been held, it is not binding, it is distinguishing. I will give a direct judgment on that point. On the basis of Arunachala, this cannot be decided. Rather, my lord, your lordship, my lord, may kindly see the Bombay judgment. Bombay judgment, your lordship, may kindly see.
Then the argument, the
This is
has
the last leg of argument.
because your ladyship, then the facts of Bombay High Court is completely different. It is co-partially
We are
property.
ready. We can't go.
No,
we have spent 1 hour on that.
Then we cannot
just
do
few
it.
things I
If
would.
you are-
Arunachala cannot be relied upon
I-
because facts are different. Then how can Bombay High Court be even
My
referred?
lord, just
Because
a
that is
moment,
completely
few things I
different.
would like to say, my lord. Nothing more. My lord, in this particular case, the court has considered Asnur Singh. My lord, the court has also considered, my lord, Arunachala judgment, my lord, and my lord, thereafter, my lord, has considered, my lord, the features of Bombay State, and then, my lord, after taking into consideration everything, my lord, the court has given this judgment. In this case also, I will say, my lord, there was no issue of widow remarriage. There was no issue of widow remarriage. I agree to that. So far as the Chhattisgarh judgment, your lordship, is concerned, my lord, Arunachala judgment has also been taken into consideration by the Honorable High Court of the Chhattisgarh. But my lord, in that case also, your lordship will find there was a son. So my lord, the Honorable Court has held that the moment the son is there, it will not go to the daughters. But so far as this fact of this case, your lordship is concerned, it is admitted position, my lord, is that my lord, there was a widow, and my lord, widow remarried with Kashi. So, my lord, the property will not go to the daughters, it will go to the, my lord, the reverseness. That is my first submission. Second, so far as, my lord, the substantial question of law, your lordship is concerned, (1937) Act has been taken into note in the Bombay judgment. In that, my lord will not find the daughter, my lord, except 1929, that is there. But in the 1937, my lord will not find daughter. That has been taken note by the Bombay High Court. And apart from that, Bombay High Court has considered this issue that Hindu Succession Act, your lordship, is not, my lord, retrospective. That aspect has also
We
been
are
taken.
not applying Hindu Succession.
Yes. So, my lord,
We are not applying Hindu Succession Act
yes.
by any means.
Then my lord will actually apply the Mitakshara. And my lord, in the Mitakshara law, even the Sapinda's column, my lord, will find the daughters are below and widow is up. So once the widow is there, my lord, the right will go to widow, not to daughters. And the moment the widow will remarry, my lord, it will not go back to the daughter, my lord. Rather, it has been totally divested. That what is there.
That's all. Just hold on. Let me calculate.
एक बात और here my brother, my learned friend is very concerned. Your lordship, the decree is, my lord, they prepared by the appellate court. Appellate court has not said anything. The trial court, that is also not in the, my lord, the proper concept. That also requires correction. That requires correction. Even if your lordship got.
Yeah, we will only decide the substantial question.
No, anyway, but what would be the effect?
I just don't get.
Effect.
Substantial question of law, whatever has not been given, that will open another round of.
आखिर तो हजूर इसको प्रॉपर्टी का जो डिस्ट्रीब्यूशन होगा, आखिर इसका तो डिस्कशन होगा. डिस्कशन में अगर डिग्री ही सही नहीं है तो डिग्री ही सही नहीं तो क्या डिस्कशन होगा. इसलिए उस पार्ट पे तो कम से कम इसको ठीक किया जा सकता है. उस पार्ट पर अगर हुजूर डिग्री होने के बावजूद भी ना हमको कोई फायदा होगा ना अदर साइड को होगा, उस पॉइंट पर तो हुजूर इसको देखना चाहिए. हम यही आग्रह करेंगे. और अगर 2005 एक्ट के हिसाब से भी आ गया है कि डिग्री के स्टेज पर भी आपको राइट देना चाहिए. उस पॉइंट पर जो एलोकेशन ऑफ शेयर इज एन इशू इन दिस. और अगर अपीलेट कोर्ट का और ट्रायल कोर्ट का जजमेंट को अगर एज इट इज मान भी लिया जाए, तब भी 57 में अगर राइट है, जैसे अगर कुछ और 56 में हाफ पोर्शन में राइट है, तो चोलाराम महतो का राइट नहीं होगा. यह राइट होगा बौनी और बिलासा का. और बौनी और बिलासा का जब राइट होगा तो उनको तो कुछ शेयर भी नहीं दी. दैट पार्ट पर तो ऐसे भी जजमेंट गलत है. उनको कम से कम हाफ ऑफ द 56 को तो डॉक्टर को अलॉट करना चाहिए था. पार्टीशन सूट पे तो हजूर वेल सेटल्ड है. एवरीबॉडी इज ए डिफेंडेंट, एवरीबॉडी इज ए प्लेंटिफ. डॉटर को 1/5 राइट दिए, 1/8 राइट दिए, 1/8 राइट आउट ऑफ द फादर शेयर दिए हैं एज पर द 1956 ही दिए. और बिलासा का जहाँ तक बात है, उसका ये रेलेवेंस इसलिए नहीं है क्योंकि उसका मृत्यु विचारण के दौरान हो चुका है. तो उसको
सब्स्टिट्यूट नहीं करना था.
नहीं, 12 की बात लिखी
हम देखें, लेकिन अगर ड्यूरिंग द पेंडेंसी कहाँ से बोलते हैं? हमको तो कहीं नहीं लिखा. आपके इंस्ट्रक्शन से हम डिसाइड करेंगे.
रिकॉर्ड में नहीं आया वो, लेकिन पारा 10 में
ये भी तो ऑब्जेक्शन है।
पारा
कोई
10 में
objection नहीं है।
एक बहन को
ऑब्जेक्शन नहीं है, लेकिन जब रिकॉर्ड देख रहे थे नजर
रिकॉर्ड
आया
पे
तो
आया
आपसे
है।
पूछ ली।
रिकॉर्ड पे आया है कि
डायरेक्ट इशूलेस नहीं आया।
नहीं इसमें आया, यहाँ ये
नॉन
आया
ज्वाइंटर का पॉइंट लिया था दोनों का,
हाँ।
लेकिन आप सिर्फ एक ही को पार्टी बनाया।
विवादक मासबीन हो जाता है विलासों की मृत्यु विचारण के दौरान हो जाती है।
कब, whether she died issueless, what is the manner she died? Initially तो उसको पार्टी नहीं बनाया,
नहीं
तो ड्यूरिंग द पेंडेंसी अगर डेथ हो गया तो नॉन ज्वाइंटर का प्ली खत्म हो जाएगा।
नहीं ज्वाइंटर का प्ली भले मौत खत्म हो, लेकिन इनका कोई इशू वैसा तो
नहीं है,
objection
वैसा
नहीं है।
कोई-
नॉन ज्वाइंटर का जो इशू होता है
सही, कोई
वो तो
substantial question of
वेरी
not नहीं
इनिशियल
बना।
स्टेज पर होता है। प्लस जब ये बताएंगे कि हाँ इसमें इनका ये वारिसान है, ये वारिसान इनको पार्टी बनाई है, हमने बनाया होता तब ना होता।
It was just an incidental question because they both of them, two persons executed the same deed, only one of them was party.
I agree to that. I agree to that. वो इसलिए नहीं बनाए थे या जो भी वजह रहा हो, लेकिन जब ये अगर इस चीज को जब स्पेसिफिकली रेज नहीं किए और ये भी नहीं बताया कि हाँ बिलासो का कौन कौन वारिसान है, क्या है, नहीं है किसी भी स्टेज ऑफ द प्रोसीडिंग में, तो अब सेकंड अपीलेट स्टेज पर आकर के कैसे इस चीज को रेज करेंगे? इसको बात को हम कहना चाहते हैं। शेयर तो इनका एकदम गलत था। शेयर भी इनका प्रॉब्लम था। उस पॉइंट पर भी डिग्री को क्या नाम है इसमें रिक्वायर्स रिमार्क।
Second appeal number 187 of 2008. This appeal has been filed by the plaintiffs against the judgment and decree dated 16/6/2008
son and daughters of
within
Qasim.
bracket 20 decree signed on 24/6/2008 passed by the additional district judge fast track court number 3 Hazaribagh entitled appeal number 11 of 2004 affirming the judgment and decree dated 20/2/2004 within bracket decree signed on 5/3/2004 in partition suit number 29 of 1994 passed by the sub-judge Roman 5th Hazaribagh. The इसका प्लेट निकाल दीजिए। हाई कोर्ट का डिग्री नहीं लगाए हैं इसमें निमो पप्पी
It has come in the records.
The suit was filed. The suit was initially filed by Pato Devi, wife of Kashi Mehto, wife of late Kashi Mehto, and 3 sons of Kasi Mehto, namely Bhola Mehto, Kushal Mehto, and Nedu Mehto, and daughters of Kashi Mehto, namely Jhumni Devi, Riva Devi, and Bhumi Devi. For a preliminary decree of 6/8 share in Schedule A and Schedule B property, and also for a declaration that the sale deed executed by Vilaso Devi and Gauri Devi both daughters of Radha Mehto, within bracket, and Radha Mehto, son of Dukhi Mehto, is collusive, invalid, void, and no title and possession passes on by virtue of the said sale deed in favor of defendant number 1, that is Chola Mehto, son of Kashmir. It is not in dispute that the parties are governed by Mitakshara's rule of Hindu law. It was the case of the plaintiff that the property was recorded in the name of Amrit Mehto, who had 2 sons, Dukhi Mehto and Kalu Mehto. And at the time of last survey operation, Dukhi Mehto had expired, so his landed property was recorded in the name of Radha Mehto, his son. It was their case that land under Khata number 15 was recorded in the name of Kalu Mehto, and land under Khata number 57 was recorded in the name of Radha Mehto, and land of Khata number 56 was recorded jointly in the name of Radha Mehto and Kalu Mehto. Dukhi Mehto died leaving behind his only son, Radha Mehto and wife Dukni Devi. The wife of Radha Mehto was Sobugi Devi, and he had two minor daughters, Bilaso and Bonnie. Radha Mehto, as per the case of the plaintiff, Radha Mehto died sometimes in the year 1936 in jointness. Both the daughters of Radha Mehto were living under the care and guardianship of their mother and grandmother. However, the widow of Radha Mehto, Kashi Mehto, son of Kailuni. It was the case of the plaintiff that at the time of second marriage, property was in exclusive possession